Hi, I'm immigration attorney at L. Brudner. In this video, I will discuss a very common question that is, I entered to the US without a visa and I'm now married to a US citizen. Can I apply for a green card in the United States or do I need to leave to my home country? The answer is you might be able to. And generally, one of the requirements to apply for your green card in the United States is that you are inspected and admitted at the border. This generally means that you have to have entered with a visa to apply for your green card here in the United States, or in the technical term, to adjust status here in the United States. There are a few exceptions to this general requirement, which I will review with you today. And as always, this is just general information, but you could get a great idea from this video. Number one, the first exception I would like to discuss is a 245I. You might have heard about that. And it stands for the number of the section in the Immigration and Nationality Act, the 245I section. And it is a special law that allows people to apply for their green card in the US, even if they entered without permission. And to qualify, you have to be a beneficiary of an approved petition that was filed on or before April 30th of 2001. Now, this petition could be filed by a family member or an employer, and it could have even been filed for your parents, and you might still be able to qualify for 245I under your parents' petition. We call this old petition a golden ticket, literally because it's like gold. If you have this, it's very powerful and will allow you to complete the process here in the United States without leaving. The second exception I want to talk about today is for members of military. And not a lot of people know this, but if you're a spouse, a parent, a son or a daughter of a US military service member, either on active duty or a veteran, then you might apply for something called parole in place. Parole in place allows people to be paroled for the purpose of applying for the green card inside the US. If you receive parole in place, you're considered to have a legal entry that you need to apply for the green card here in the United States. So it's also a very powerful thing if it applies to you. Another exception to the rule are Vawa self-petitions. Vawa stands for Violence Against Women Act, and it is available for certain people that have suffered abuse or extreme cruelty by a US citizen or resident family member. And VAWA allows you to apply for your green card by yourself. It's a self-petition. You do not need the help of a US citizen or green card holder family member. And as a VAWA self-petitioner, the initial entry without a visa does not disqualify you from applying for the green card here in the United States. So that means that if you have an approved VAWA petition, you can apply for your green card here in the United States without leaving, okay? You don't need that legal entry. Finally, there's some humanitarian options that also will allow you to apply for a green card here without leaving. Those are the U visa. The U visa is a visa that is available for people that have been a victim of a certain crime here in the United States. So if you received a U visa, you can then apply to adjust your status here, and it doesn't matter if you entered without a visa. And another humanitarian option is asylum. So if you were granted asylum, after 1 year, you can apply for your green card here in the United States, and you don't need to have that requirement for the lawful entry. Now, if you meet one of these exceptions, like I mentioned, you might be able to apply for the green card, even if you came in unlawfully without a visa, but it's a very complicated area of the law. And I really recommend to consult with an immigration attorney before you file anything with immigration. Okay, don't do these kind of cases yourself. So if you have any questions, please leave us a question below and subscribe to our channel to receive more videos.